The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeal. I'm your host, John Ross, of the Institute for Justice's Center for Judicial Engagement. Joining me today are Robert Fromer, who is a senior attorney at our headquarters in Arlington, Virginia, as well as Justin Pearson, who is the managing attorney at our Florida office in Miami. One quick note before we get into the cases. Last week, the Supreme Court accepted review of a case that we talked about a few episodes ago at our live episode on the Third Circuit at the University of Pennsylvania. The case involves Delaware's system of selecting state judges. The state has a law requiring judges to be either a registered Republican or Democrat. Members of third parties cannot be selected for the bench. And the Third Circuit struck the law down for violating the freedom of association. At the same time, the panel said Delaware's judiciary is widely admired for its professionalism and competence and lack of partisanship. But now the Supreme Court is going to take another look. Gentlemen, do you have thoughts?
I think it's a really interesting case. The opinion touches on whether judges are policymakers or not. Given the current makeup of the court, I think we are going to see a very interesting opinion, regardless of which way the court rules. I think the court will ultimately affirm the Third Circuit, but regardless, I think we're going to see a really cool opinion that talks about judges' roles and whether they're policymakers, and I'm looking forward to reading it.
And what I think is going to be interesting here is the different approach that the Third Circuit took versus the Sixth and the Seventh Circuits, in which it explicitly noted in the opinion that its version of what a policymaker is a much more circumscribed than what the Sixth and the Seventh Circuit were saying, which is really anyone who is making decisions that have a broad effect on policy. That exception seems to swallow the general ban on conditioning employment based on political affiliation. My guess is that the Supreme Court, when they hear this, will probably try to set out a clearer test for lower courts to apply going forward.
Okay, and with that, let's move into this week's cases. Rob.
All right. Well, the first case this week we have is out of Seattle. It's named Willis versus City of Seattle, and it involves a situation where the Seattle police, along with some state officials, were going into homeless camps and under what the plaintiffs say is a policy, essentially destroying any personal property that they would find in those camps that they thought was worth less than $100. And they were doing this, obviously, without any notice ahead of time, without any opportunity to give a hearing, etc. So a group of homeless advocates, along with the ACLU and other groups, brought a challenge to this practice at the district court, where they were denied class certification. They said, the district court said that the issues that they were talking about weren't common to everyone in the class, which was a little surprising. And then when it came up to the Ninth Circuit, we end up with a split decision, with two justices, one of them sitting by designation from the Court of International Trade, saying that you didn't say the right magic words here in claiming that you were making a facial challenge, and therefore the district court was fine to not rule on that. The dissent, I think, quite persuasively, by contrast, points to various parts of the record at the district court level, not just the complaint, but the motion for class certification, and I think most importantly, the motion for preliminary injunction, where it was crystal clear that they were challenging these regulations and rules that gave officers that discretion. They were challenging it on their face. So it'll be interesting to see if the ACLU and other groups try to take this en banc to the full Ninth Circuit. I think there's a bit of a there, and it's important that these kinds of cases get decided.
Justin?
Yeah, it was a really interesting opinion because, like you, Rob, I was persuaded pretty strongly by the dissent, and obviously the majority read the dissent and was aware of the argument made by the dissent that, hey, hold on a second, guys, they actually did allege that it was a facial challenge. They might not have used the word facial, but if you read the pleadings, they allege that this was a law that was unconstitutional in all of its applications, regardless of which words they used to make that point. And yet, even after being apprised of this by the dissenting judge, the majority still held firm and insisted that the class certification be denied. It just makes no sense to me.
And I think ultimately this is a bit short-sighted on the part of the majority, because ultimately at the end of the day, I think what they're trying to do is control their docket. But what's really going to happen here is that this case isn't going to go away, even if it doesn't get it gets denied by the en banc court and it's at an end. What's going to happen is that the ACLU and these advocates are simply going to put together a new lawsuit using all those magic words that the majority said that they failed to include the first time, and we're just going to get this all over again. It seems like the simpler course of action would be to simply remand it back down to the district court, say, it does look like they brought facial claims. Can you decide whether those can go forward as a class? That would be a much better use of judicial resources than basically starting from scratch.
Yeah, I completely agree.
Why does this need to be a class action case? Why can't a few individual plaintiffs challenge an individual seizure?
Well, they can challenge individual seizures, but what they're wanting to challenge here is the broad policy. So in this, and in some cases here at the Institute for Justice, we do challenge broad policies where we don't bring a class action. It's just on behalf of a few people, but they're challenging a common rule. I think what they're trying to do here with the class action is make sure that, especially with a transient population like the homeless, that they might well lose some of their plaintiffs during the case. They might move, they might become unavailable. And a class action allows the case to continue regardless of the fortunes of the individual plaintiff. And that's part of the reason why we at the Institute for Justice have been doing more class actions when we're trying to attack big, broad structural problems in cities, like what we had in our Philadelphia forfeiture case.
Seattle officials have declared that they have a homelessness crisis. They're trying to do something to attack the problem. What other options do they have?
Well, I mean, first of all, this is a complicated problem, obviously. But first of all, one thing they could do is stop restricting the building of new housing and messing with the market in a way that then makes housing prices skyrocket. You know, if the government just got out of the way, and particularly if they stopped doing the bidding of people who don't want new construction, there would be more housing available for the homeless. There are also all sorts of other problems, like actually trying to help them find jobs and things like that. There are all sorts of other ways the government can help if it wants to. Perhaps this is not the best one.
Well, and at the end of the day, what's a good for policy and what's a good policy idea or a bad policy idea, that might be one thing, but we're talking about people's constitutional rights at the bottom here. Their rights to be free of programs that give unfettered discretion to officers. That's something that is, regardless if you're homeless or not homeless, you want the government to be acting in a constitutional manner.
And just like in our civil forfeiture cases, who do you call when it's the police who stole from you?
Okay. With that, let's move to the next case. Justin?
So we move from a perplexing Ninth Circuit opinion to a downright disturbing one. I should also point out that this case is currently has a cert petition pending, and IJ has filed an amicus brief in support, authored by our colleague Paul Sherman. And for fans of First Amendment jurisprudence, this should get you riled up because it has to do with the case, a very famous case called NAACP versus Alabama, which held is a 1958 Supreme Court opinion that held that the NAACP did not need to turn over a list of its members to the state of Alabama. Obviously, this was during the Civil Rights Movement. There were obvious reasons why Alabama wanted that list for nefarious reasons and why it would be very detrimental to the NAACP and its members if it had to turn over that list. Fast forward to modern times. Thankfully, what happened to the NAACP during the civil rights era is an extreme situation. But that being said, there are still very legitimate fears at play when donors to certain groups need to turn or need to out themselves as donors. Many times people want to contribute anonymously, and that's particularly what's going on here with AFP, Americans for Prosperity Foundation. There was evidence presented in the district court saying that when these donors are revealed publicly, they face death threats. The addresses of their kids' schools will be posted, all sorts of horrible things that they would obviously like to avoid. Yet, despite that, California is insisting, and this is really what gave rise to the lawsuit, California is insisting that all of these 501c3 charities turn over their donor lists, even though they have presented no evidence that they're actually going to use them in any way. And on top of that, they have shown themselves to be completely incompetent when it comes to keeping those lists confidential.
Oh, and the district court made a big point of that. So noting all the times that they had released the data inappropriately, even I think up to even after California had said they'd fixed the problem. But all that was, in the Ninth Circuit's view, at least for the majority here, for the panel, was immaterial, because they said that a legal standard known as exacting scrutiny, which was originally developed in the election context, applies here instead of the strict scrutiny that they used in NAACP versus Alabama. And that had hugely important effects on the case, because under strict scrutiny, the government needs to show that what they want to do is the least speech restrictive alternative way of achieving its interests. And obviously what California was doing is going to chill a lot of people who might otherwise give to AFP.
If I could just back up. So
Yeah.
California has a law that requires nonprofits to turn over their donor lists to the state. And in theory, those donor lists will be kept secret. They're not going to be publicized. In theory. But the state messed that up. Repeatedly. And so AFP's donor list was publicized. Anybody else? Was it everybody, or was it just right-wing groups?
There have been other groups as well, not just right-wing groups as well. Like Planned Parenthood had some of their donors revealed. So it's not simply a partisan issue. But I just want to point out that, and Rob obviously is totally right about the legal errors, but the majority opinion manages to be simultaneously wrong on both the laws and the facts. So first of all, they misapply the law. They take this narrow exception from the Buckley case that had to do with campaign finance reform, that basically has to do with a political speech, pure political speech. And they take that narrow exception that's problematic in its own right, and now they do what government always tries to do with those exceptions, and what unfortunately courts all too often allow them to do, which is to shoehorn other things into that exception. No one is claiming that's what's going on here with AFP and with the other people who don't want to turn over their donor lists is campaign finance speech. It's speech in furtherance of a political campaign. But nonetheless, they've taken this Buckley precedent that doesn't apply, and they've applied it anyway. And in doing so, they're applying exacting scrutiny instead of strict scrutiny. And again, that's not to go too far off on a tangent, but exacting scrutiny itself is problematic. But then on top of that, they don't even really apply exacting scrutiny, because the district court conducted a trial where it made a series of factual findings showing how the state had repeatedly failed to keep these lists private, showing that there was a pretty good risk that they were going to be made public again, showing that the harm suffered by the donors, that threat of that harm was reasonable. And yet, despite all those factual findings, what the majority does at the Ninth Circuit is they really apply something that looks a lot like the rational basis test. They call it exacting scrutiny, but they bend over backwards to disregard all of the facts. And so it's really troubling. It really is.
Yeah. Which they then claim they have to ignore those facts because, in their view, exacting scrutiny, which again comes from the electoral context, has somehow occupied the entire field, meaning that NAACP versus Alabama and its whole line of cases are no longer valid.
Right.
This should be something that the Supreme Court looks at. It's had a long history of protecting people's right to speak without being subject to harassment, and the record here of the harassment and threats that the speakers received is quite chilling. So I hope that they take this up.
Yeah, and in defense, to the Ninth Circuit, although I'm loath to defend them, the Second Circuit actually did something similar. So now we have two circuits who have started chipping away at these protections of political speech, of association, of associating with people when it's not speech in furtherance of a political campaign. And I'm worried that if the Supreme Court does not grant this cert petition, that other circuits will do the same thing, and these protections will just continue to be eroded. So hopefully the Supreme Court will grant cert.
I would say this is an example of a larger problem that we often see with the federal courts. It's that the lower federal courts, district courts, but often the courts of appeal as well, because they they tend to have more of a pro-government bent. And what happens is that the Supreme Court will set a rule like it did in NAACP versus Alabama. And then the lower courts start chipping away at that, trying to start finding exceptions. And ultimately, it becomes the duty of the Supreme Court to put the line in the sand and say, no, we really meant what we said. And I think that's what's going to happen here as well.
I think that's right. And I should also point out that this isn't just something we see with campaign finance regulations. We see it in all of our work. Anytime you have different burdens that could be placed on the government is always trying to find a way to shoehorn their harmful regulations into the rational basis test, or if it should be strict scrutiny, intermediate scrutiny. They're always trying to chip away. And it does seem like they tend to be successful at the circuit level. Even when they're up on appeal at the circuit level, the circuit judges tend to be far too willing to let the government chip away at these protections, and the Supreme Court is the ultimate backstop.
And now for some pre-recorded commercial content. Here I am in the studio with IJ President and General Counsel Scott Bullock. Scott, can you give me a podcast-sized explanation of what IJ does?
Well, I think in corporate speak, that's sometimes called like an elevator pitch. And so I usually don't talk that way, but I'll give it a go here now. The Institute for Justice defends everyday Americans whose basic constitutional rights are violated by the government. So things like the right to keep their property, to speak freely about business or politics, to earn an honest living in the occupation of their choice, or to direct the education of their children.
Scott, that's some pretty lofty stuff. How's our scorecard looking?
We win nearly 3 out of every 4 cases we file, and we deliberately pick the tough cases that will have the biggest impact on the liberties for all Americans.
It's expensive to do this kind of litigation. How much do we charge our clients?
I'm happy to say we don't charge them a thing.
Really?
Yeah, our clients don't pay IJ a penny, no matter how long their cases take to litigate.
So how do we keep the lights on here, Scott?
Well, people can become IJ supporters. Every penny that IJ spends fighting government abuse comes from people like your listeners who care about liberty and who are committed to defending it now and for generations to come. So you can go to ij.org/donate to make a secure online gift. And because IJ is a nonprofit, all gifts, I'm pleased to say, are tax deductible.
So if you care about IJ, or you care about my personal job security, please do click on the link that we'll include in this week's episode description. Okay, one more case today.
All right. Well, the last case we have today comes from Texas. And this is a case about an interesting law. It's the fight of, local versus state governments. So as everybody probably understands, the federal government provides vouchers for low-income individuals to rent houses, rent apartments, houses. And in a lot of places, some landlords don't want to accept those, and they don't have to. Well, the city of Austin didn't care for that. They figure that they want, if you have a voucher, it should be accepted same as cash, and people shouldn't be able to deny it. So the city of Austin passed an ordinance saying just that. If you have a Section 8 voucher, that's that low-income housing voucher, landlords can't turn you away because of that. They have to accept it. And in response, the state passed a law saying that cities couldn't pass ordinances like that and can't enforce ordinances like that. So now we have the city on the one hand trying to prevent landlords from not accepting these vouchers, and then we have the state saying to the city, no, you can't do that. And then the city said, okay, well, we're going to sue you, state, in federal court. So this is a very bizarre situation where we have a city suing a state in a federal court. And what essentially happened in this case is that the Fifth Circuit said that the case could not proceed. The city's case could not proceed against the state because it said, well, ultimately, city, you aren't being prevented from doing anything. Even though this law is in place, saying that you can't enforce this law, that doesn't really constrain you in any way. You could still enforce it, and then I guess the state may or may not come in and intervene in the case and say that, no, you can't enforce this law because of the state statute, even though the Attorney General had done so with other ordinances like this one in the past.
So, for instance, if a private individual were to violate state law, they would be risking jail time. But Austin, the city itself, if it violates the state law and enforces its ordinance, they're not really facing jail. I don't know. Would they be facing monetary penalties or?
It wasn't really clear from the state law. It just says that the cities are prohibited from enforcing this, but it didn't, at least in the opinion, they didn't lay out, or at least I didn't see a penalty towards that. And I think that was a large part of the Fifth Circuit's decision. Like, well, maybe the state will come in and maybe the state will oppose what you're trying to do to enforce your ordinance. And then you can have that fight at that time. You can fight about whether you can do this or not, whether you're the state law prohibiting the city from requiring landlords to take Section 8 vouchers is itself preempted by federal law. They're just saying we don't need to decide that now. That can be decided in an enforcement case down the line.
Right. And I also thought one thing was interesting was the court talked a lot about who the actual named defendant should be. And they pointed out that, the plaintiff mentioned the Attorney General by name, and then it mentioned the Texas Workforce Commission as an entity, but it did not name any actual individuals who either run or are part of the Texas Workforce Commission. And so the opinion seems to strongly imply that if they had named some individual officials who are members of the Texas Workforce Commission, which is the relevant state body, that would have survived. But what you can't do is just name that agency without the individuals, or just name an individual who's like the AG or the governor without naming the actual specific state body who's in charge of that regulation. So it seems like they named anyone that they could conceivably name that's related to this, except for the ones that the court actually wanted them to name, which would have been the individuals who work for this workforce commission. Although they don't really say it as clearly as they could have, so maybe they'll try and we'll see.
Well, and that's also a little bit, though, in tension with their idea, like, you're not really being constrained from doing anything, city. You can enforce this thing. Maybe the state will come in at some point and say you shouldn't be doing this. They'll intervene in a case. I think I disagree with you about them naming the workforce commission a commissioner in this situation. I don't think that there was, given the way that this law is structured, the state law is structured, and what appears to be, at least in the Fifth Circuit's view, the lack of any real penalty or constraining of the city, I don't think that they were going to let this go no matter who they named. I think it's ultimately they're saying, just wait until there's an actual enforcement thing, and we'll see what happens then.
It's possible, but I wouldn't be surprised if, based on some of the things that were said in the opinion, that this lawsuit weren't refiled against individual members of the Workforce Commission. Now, when that happens, you might end up with the same result. Like, I understand what you're saying, Rob, but I think there's enough there to give them a glimmer of hope that if they were to file it against the individual members of the Workforce Commission, they'd at least be able to present the arguments. And then they might still lose for the reasons you mentioned, but it did seem like there were a couple issues, and one of them was this idea that maybe they didn't name the right defendants.
Yeah.
It seems like pretty harmful for IJ cases if, when the state passes a law, you can't sue over it unless it's been enforced against you. Pre-enforcement challenges is, pretty big part of our mission.
Absolutely. It actually is a huge issue in my case that we now have at the Maryland Court of Appeals, the highest court in Maryland. There, we challenged a law that said you couldn't sell items that were of the same food type that were within 300 feet of a business that sold the same kind of food. And of course,
mobile vendors can't sue within 300 feet of a
they can't sell within 300 foot of a brick and mortar. Of course, the city had no idea what any of that meant. They couldn't say what any two food products were the same type. But what the middle level court, the Court of Special Appeals, said is that we couldn't sue on that because our people hadn't actually been fined and enforced against. So even though it was a criminal law and it's hanging over your head, you can't bring suit. That's a huge concern, and that's something that we're greatly concerned about in all of our cases.
Yeah, that's true, and it is absolutely true that that's something we encounter quite a bit in our cases. I do want to point out, though, to be fair, cities are, as a matter of state constitutional law, creatures of the state, and so a judge is likely to look at a lawsuit brought by a city against the state entity that actually created that city differently than if citizens bring a constitutional challenge. So I'm not sure it's exactly apples to apples, but you're absolutely right that it is an issue we face constantly. So we're always, hyper aware.
Okay. Well, then that concludes the show. Thanks for listening. We appreciate you. Be sure to tune in next time for more judicial engagement. Until then, this is John Ross from the Institute for Justice, encouraging you to get engaged.